lawyer representing 130 City of Johannesburg employees who won a labour court case says his clients are delighted at the outcome of their matter. In February, the DA-led administration planned to terminate the employees' permanent contracts. The contracts were converted to permanent from fixed term by the previous ANC-led administration. But the Labour Court order last week interdicted the city from going through with the retrenchments pending the outcome of deliberations at the Bargaining Council.
We're actually quite delighted, as you may gather, because, we feel that we were finally vindicated on behalf of the City of Johannesburg employees who brought an urgent application in the Labour Court, which basically has resulted in the halting of the implementation of a resolution that was taken by the current city administrators to try to terminate contracts of employment that belong to our clients, which of course, our view was that was not managed correctly.
Let's bring you more on the story. Employment and Labour Specialist Osborne Molatudi of Molatudi Attorneys joins us now. Good evening and thanks for your time. Look, I suppose one of the big issues here is that by and large, the employees accuse the City of Joburg of not having followed due process in coming to the decision to terminate their contracts. The decision by the Labour Court, is it justification and vindication, perhaps is the better word, for these workers?
Good evening, Kathy, and thank you for having me on your show. Well, I've got one way to say this. There's a victory for the employees affected, and there's also a victory for the City of Johannesburg. Why I say this is that the employees in particular, Kathy, they applied for what one can refer to as an interim interdict, pending the determination of the dispute on the very same issue at the Bargaining Council. So the fairness or otherwise of their dismissal or their conversion back to what they were supposed to be was referred to the Bargaining Council, and on that basis, just hold on one second, I'm getting disturbed here. On that basis, so they got the interim interdict in their favor. However, insofar as the determination by the Bargaining Council, the Bargaining Council has now ruled that the referral of the dispute was premature, and therefore the affected employees must actually wait when the dismissal happens, which is at the end of this month. So one would imagine that the employees in question will make a fresh referral to the Bargaining Council. And I must just add that the lawfulness or otherwise of the actual conversion and the rescission of the decision by the mayoral committee, which back then was under a different political organization, was not decided by the Labour Court. So an impression must not be created that there was already a determination. It was just simply an application for an interim interdict.
And it's really the merits of that case on that issue that employees are most worried about, because many say that they were taken through thorough interview processes. These positions were advertised, and therefore this idea that, they were simply given these jobs and that some of them don't qualify for these jobs is simply untrue. When are we likely to see this aspect of the case ventilated?
I think that's a very important question, Kathy. And the best forum for the benefit of your viewers will be the very same Bargaining Council, because at issue would be whether or not there was, firstly, a unilateral change to terms and conditions with what the current administration want to do, and secondly, whether or not there was a dismissal, because if you rescind a decision that converted these fixed-term employees into permanent, and that means that there is no permanent employment. Now, is that unilateral change to terms and conditions, or is that a dismissal? So that's precisely what will be determined by the bargaining council. And yes, the merits of the actual case. For now, the employees were given an interim reprieve in the form of interim interdict, saying that no finalization of the conversion from fixed term to permanent can be made until such time that the bargaining council has decided the issue. And I know the city is saying that it has also been victorious because the bargaining council has now made a determination. That's not how I read it, Kathy. How I read it is that they said the dispute referral is premature because termination has not yet happened. So, as I said earlier, the employees have to wait until after the 30th of April, which is, as we know, it's next week.
What is the purpose of this interdict then? Does it mean that come the end of this month, these employees can't be dismissed, or that they can't be dismissed before the end of this month?
I think on an objective reading of the outcome, it simply means no final decision can be taken, no final implementation of that decision can be taken until such a time that the bargaining council has pronounced on the issue. But as I said, it was more of a short-lived victory because unfortunately the bargaining council said it does not have the jurisdiction because as far as it's concerned, the dismissal has not yet occurred. So it's going to be quite interesting as to what will happen on the 30th. Or on the 1st, which is Workers' Day, when the workers are supposed to be celebrating Workers' Day, they should be more worried about their right to refer disputes, either for unilateral change to terms and conditions or for a dismissal, if the city goes ahead and implements its decision.
Osborne Molatudi, who is an employment and labor law specialist, thank you so much for your time.